You think Gen Z today is really bad, cheap, selfish, opportunist, and shallow? You are wrong. This pathetic, shameless thinking has been going on since old times. People from older generations were actually more disgusting and more low class because there was no internet back then. Because of that, their shamelessness and bad behavior did not come out in public most of the time. And we sit here imagining that they were very decent, nice, innocent, and simple people. But that's not true. They were more insensitive, lustful, and shameless than today's generation. You can judge that clearly from today's case. The murder of Mary Jolene Friess in August 1954 and the subsequent execution of Bernard Schreiber in March 1956 represent a significant chapter in Ohio's legal history, particularly concerning juvenile offenders and capital punishment. In today's video, we will examine the factual sequence of the events, the investigation, trial proceedings, and the broader implications of the case within the historical context of capital punishment in Ohio. On August 12, 1954, 17-year-old Mary Jolene Friess was murdered while riding her bicycle to retrieve mail near her rural home in Sylvania Township, Lucas County, Ohio. Mary was born in June 3, 1937 in Sylvania, Ohio, was attacked by two individuals, 17-year-old Bernard Schreiber and a 12-year-old boy whose name was not publicly disclosed due to his age. The culprits had stalked Mary for 3 days, observing her routine and making indecent proposals. When she rejected their advances on August 11, they decided to wait for her the following day. On the day of the murder, as Mary rode past them, the boys ambushed her. The 12-year-old boy knocked Mary from her bicycle by striking her with a club. Dizzy and attempting to flee into the woods, she was struck twice more and knocked unconscious. The younger boy then left the scene while Schreiber dragged Mary deeper into the woods, tore her clothes, and sexually abused her. When Mary regained consciousness, Schreiber became concerned that she would identify him and stabbed her twice in the chest with a pocket knife, which eventually killed her. After the murder, Schreiber returned home and ate lunch, displaying no apparent remorse or concern for his actions. Mary's body was discovered later that evening by a neighborhood search party after she failed to return from her errand. Her pink blouse and blue denim shorts were torn, and medical examination confirmed she had been sexually abused. The brutality of the crime shocked the community and prompted an intensive investigation by local law enforcement. The investigation initially stalled until authorities received an anonymous tip from a woman who reported that Schreiber had confessed the crime to his mother. When police confronted Mrs. Schreiber, she expressed being ashamed but uncertain about how to proceed. She quoted her son as saying, "I just killed a girl. I stabbed her twice." Schreiber initially denied involvement but agreed to undergo a lie detector test. The test revealed marked discrepancies with his initial denials, and when confronted with the results, Schreiber confessed readily. Showing no sign of emotion, he put his feet on the prosecutor's desk, puffed a pipe, and calmly related how he and the boy he planned the crime. Before making his formal statement, Schreiber took deputies to a dump 2 miles from the murder scene, where they recovered fragments of Mary's eyeglasses that he had attempted to conceal among the rubbish. During his confession, Schreiber provided chilling details about his motives. He stated, "She looked good. We decided to wait for her. I was intrigued and aroused by the way she was dressed in bra and shorts. She had a pretty nice looking shape, and that's what got me." He admitted that his actions were partially motivated by teasing from classmates about his virginity and his desire to prove his manhood. The 12-year-old accomplice, when confronted, cried and denied involvement in the murder but admitted to his initial participation in the assault. Bernard Schreiber was charged for the first-degree murder and waived his right to a jury trial, opting instead of a bench trial before 3-judge panel. The trial began on January 10, 1955. Schreiber entered a plea of not guilty by a reason of insanity, but 4 psychiatrists testified that while he was intellectually disabled with the mentality of an 11-year-old and academic performance at the 7th grade level, despite being in the 11th grade, he was sane at the time of the crime. The prosecution argued that Schreiber's learning difficulties, poor similar background and age did not warrant leniency given the brutality of the crime. Prosecutor Harry Freiberg emphasized, "Never mind, and I mean never, should this man be in the position to commit a similar crime again." A critical aspect of the trial involved Schreiber's shifting narrative about a accomplice role. Initially, Schreiber implicated the 12-year-old as fully involved in the murder. However, at the trial, he claimed the younger boy was more responsible than initially stated, saying, "Go ahead, get it over with." Schreiber claimed the boy waited at the road and asked, "Are you finished so soon?" Upon his return, this change in story occurred after Schreiber learned that if the younger boy were implicated in the murder, he would be sent to a reform school until his 21st birthday. The 12-year-old had not been charged due to his age and the lack of direct involvement in the fatal stabbing. He had been released to his mother's custody and denied all involvement on the stand. The three-judge panel deliberated for only an hour before finding Schreiber guilty of first-degree murder and sentencing him to the death by electrocution. The panel rejected pleas for a second-degree murder, conviction, or mercy. Upon hearing the sentence, Schreiber dropped his head and closed his eyes, while his mother became hysterical and his two sisters sobbed. Schreiber later said, "It felt just like they had shoved a knife in me." The original execution date was set for June 1st, 1955, but it was stayed 3 times as Schreiber's appeals progressed through the courts. Bernard Schreiber was born in Monclova, Ohio in 1937, making him 17 years and 11 months old at the time of the murder. He had spent most of his life in suburban Toledo before his family moved to Spencer Township, described as a religiously minded youth who never missed a mass. Schreiber was also characterized as a stoop-shouldered loner who never had a date and was teased by classmates for being a virgin. This teasing reportedly motivated his desire to prove his manhood through the sexual assault and murder of Mary. Schreiber's interests and behaviors were somewhat unusual for his age. He was an avid reader of comic books, particularly Superman and Captain Marvel, and enjoyed watching television mysteries, especially Dragnet. He had no particular hobbies, but liked to fool around with carpentry and mechanics. Sheriff William Hirsch described Schreiber's behavior as a sort of Dr. Jekyll and Mr. Hyde, highlighting the contrast between his religious observance and the brutality of his crime. Despite his intellectual limitations, Schreiber was able to plan the crime over several days and attempt to cover his tracks by disposing of evidence. The psychological evaluation presented at the trial revealed that Schreiber had the mental capacity of an 11-year-old, but the psychiatrist testified that he understood the difference between right and wrong and was thus legally sane. This assessment was crucial in securing the death sentence, as Ohio law did not prohibit executing intellectually disabled individuals at the time. The Supreme Court would not rule that executing intellectually disabled individuals constitutes cruel and unusual punishment until 2002 decision in Atkins versus Virginia case. Following his conviction and sentencing, Schreiber's legal team pursued multiple appeals. On June 28, 1955, an appellate court confirmed the verdict in a 2-1 decision. On December 14, 1955, the Ohio Supreme Court rejected his appeal and scheduled his execution for January 13, 1956. Governor Frank Lausche delayed the execution on December 30 to March 15, 1956 to allow Schreiber to seek forgiveness from the Ohio Pardons and Parole Commission. During the clemency hearing in January 1956, defense attorney Marcus L. Friedman argued that Schreiber had been raised on the edge of poverty and had never had a real break in his life. Friedman contended that clemency would be the first and last break he'll ever get, noting that any sentence less than death would likely result in Schreiber being paroled in 1970 or 1980s, since life without parole was not an option in Ohio until 1993. The defense emphasized Schreiber's age and intellectual disabilities as mitigating factors, but the panel was unmoved. On March 15, 1956, Governor Lausche announced that he would not intervene. After consulting with his cabinet and reviewing the case, he stated, "Based on a careful study of the evidence in the case of Bernard Schreiber, I find the facts to be of a nature not warranting my intervention. The decisions, respectively, of the common pleas, appellate, and the Supreme Courts will not be disturbed." This decision sealed Schreiber's fate, and he was executed later that same day. Bernard Schreiber's execution was was not an isolated event, but rather the culmination of a historical trend in Ohio's approach to capital punishment for juvenile offenders. Between 1880 and 1956, Ohio executed 19 juvenile offenders, all for murder, making Schreiber the last. The first juvenile executions in the state occurred in 1880 when three teenage boys, George E. Mann, 16 years old, Gustav Adolf Oher, 15 to 17 years old, and John Samet, 18 years old, were publicly hanged in Canton, Ohio for robbery and murder. Even in 1880, there were pleas for mercy on behalf of these young offenders, but over the next 76 years, Ohio courts became increasingly reluctant to sentence juveniles to death. Schreiber's case was notable because he was 17 years and 11 months old at the time of the murder, making him nearly an adult. The prosecutor at his trial perceived and described him as a young man rather than a child, which likely influenced the severity of the sentence. When Ohio restored the death penalty in 1981, lawmakers specifically prohibited it for offenders under 18 at the time of their crimes, solidifying Schreiber's morbid historical footnote as the last juvenile executed in the state. The national perspective on juvenile executions has also evolved significantly. In Thompson v. Oklahoma case in 1988, the U.S. Supreme Court held that executing individuals for crimes committed under the age of 16 constitutes cruel and unusual punishment under the 8th Amendment. This decision reflected growing consensus that younger offenders possesses diminished culpability and greater potential for rehabilitation. By 2005, the court in Roper v. Simmons extended this prevention to all offenders under 18 at the time of their crimes, effectively ending the practice of juvenile executions in the United States. Ohio's current death penalty law excludes crime committed while under age 18, and no juveniles are on the state's death row. This represents a significant shift from the era in which Schreiber was executed, highlighting evolving standards of decency and legal protections for young offenders. Schreiber's case serves as a stark reminder of a now largely abandoned practice and the complex interplay between age, culpability, and capital punishment. On the morning of March 15, 1956, the Ohio State Penitentiary in Columbus prepared for the execution of Bernard Schreiber. The 19-year-old who had spent the last 13 months of his life on death row was granted a request that underscored the peculiar companionship that sometimes developed among condemned men. Schreiber asked to eat his final meal with Benjamin Meyer, a 26-year-old inmate also awaiting execution for the murder of his wife. The prison authorities allowed this request, and the two men shared a last meal that was significant and specific. Schreiber's menu included fresh shrimp cocktail, roast prime ribs of beef, French fried potatoes, buttered whole greens, head lettuce with mayonnaise, pumpkin pie with ice cream, hot rolls and butter with strawberry preserves, coffee, milk, and Coca-Cola. The presence of Benjamin Meyer, this final meal, provides a striking contrast to Schreiber's fate and highlights the unpredictable nature of judicial clemency process in the era. While Schreiber was preparing to die for a crime committed as a juvenile, Meyer was scheduled to die just days later for a crime committed as an adult. Yet Meyer would ultimately receive the mercy that Schreiber was denied. Their stories intersected in that death house cell, bound by the shared proximity of their impending deaths, but separated by the governor's pen. As the hour of execution approached, Schreiber was moved to the execution chamber. He maintained the stoic demeanor he had displayed throughout his trial and sentencing. He had no final statement for the witnesses or the press. Instead, as he was strapped into Old Sparky, the state's electric chair, he quietly recited the Lord's Prayer with two priests who attended him. At 8:02 p.m., the switch was thrown. Bernard Schreiber was pronounced dead shortly after, the last juvenile offender to be executed in the history of Ohio. His death marked the end of legal battle that had traversed the Lucas County courts, the Ohio Court of Appeals, and the Ohio Supreme Court, ultimately concluding in the governor's refusal to grant clemency. The execution of Bernard Schreiber closed a long chapter in Ohio's legal and penal history. He was the 19th juvenile offender executed in the state since 1880, and he would be the last. Ohio continued capital punishment for exactly 7 more years after Schreiber's death, ending with the execution of Donald L. Rainbolt on March 15, 1963, a grim coincidence that marked the final execution before a nationwide moratorium on the death penalty took effect in the 1970s. When Ohio reinstated the death penalty in 1981, the legislature had shifted its views significantly, informed by evolving national standards and legal precedents. This new statute explicitly banned the death penalty for offenders who were under the age of 18 at the time of their crimes. This legislative change solidified Schreiber's status as the morbid historical footnote, the legal landscape that allowed a 17-year-old with an intellectual disability to be executed for a crime committed in the moment of violent impulsivity had vanished. Today, under Ohio law and rulings of the U.S. Supreme Court, such an execution would be unconstitutional. The contrast between Schreiber's case and modern law is most evident in the handling of the accomplice. The 12-year-old boy who helped stalk and knock Mary Friess unconscious was released to his mother and never charged with a serious crime. The law at the time, and certainly today, struggled to hold a preteen criminally liable for a murder committed by an older accomplice. Schreiber's attempt to shift the blame to the child during his trial, claiming the boy urged him on, was viewed with skepticism by the court. This dynamic highlights the often arbitrary lines drawn by the legal system regarding age and culpability. Schreiber was just weeks away from his 18th birthday, yet the small margin placed him in the category of an adult eligible for execution, while his 12-year-old partner was viewed as a misguided child. Mary Friess remains the true victim of this narrative, a young woman whose life was cut short in a horrific act of violence. The proof of manhood that Schreiber sought to steal through her death ultimately led to his own end in the electric chair. Today, Schreiber's execution is viewed through a lens of historical anomaly rather than justice. It marks the end of a practice that society eventually came to deem unacceptable. Bernard Schreiber entered the history books as the last of Ohio's executed children, a title that stands as a permanent marker of how far the law has traveled in the intervening decades. That's it for today's case. I hope you liked it. If you have any suggestions about cases you want me to cover, you can tell me in the comments. You can also let me know what overall improvements I can bring. Like and subscribe. Seriously guys, seriously, like and subscribe to the channel. It really gives me motivation to work on to the next project. Till then, goodbye and good night.